Hello, this is Kevin Thompson, and I am pleased to welcome you all to the Davis McGrath LLC IP webinar series. Today's for October 5th, 2011 is on the topic of copyright basics. And I'd like to let people know that the recording and slides will be posted at our blog at the address shown there on your screen. And there you can also sign up for our webinar mailing list. Our next webinar is coming up on November 2nd, 2011, again from 12 to 12:30 on the topic of common trademark application problems. The blog also has recording from our prior webinars as well. So today we're going to go for about 30 minutes, and we're going to cover a topic that is near and dear to my heart, which is copyright, which is a rather interesting area of intellectual property, and it's one that a lot of people think that they understand, but they don't necessarily know all the nuances, or they may not have a familiarity enough with some of the problems that can arise. So today we're going to go through some basics, and please feel free at any point if you have questions to please ask them through the webinar service. That's what it's here for, and we'll also have time at the end for questions as well. So today we're going to cover in this 30 minutes what is copyright, when does copyright exist, do I need to register, what are the benefits, what is copyright infringement, what are the damages, and then at the end I'm going to cover with how to deal with online infringements. So the C in a circle is the copyright symbol, which is differentiated from other symbols such as R in a circle, which is for registered trademark. C in a circle should be applied as a notice, but it's not a requirement. You don't have to let people know that you have a copyright. It's so certainly beneficial, and it puts people on notice of your rights, but under current law it's no longer a requirement. So what is copyright? And the statutory definition is that copyright protects original works of authorship that are fixed in a tangible medium of expression. So what does that mean? Original works of authorship, generally that means that it's something that took a modicum of creativity to create, such that it's original, but it's not necessarily the only version of the work. Let's say, for example, you have two photographers taking pictures that are side by side of the same event. They each could have original works of the same piece, because they are each independently creating their individual work. The second element is fixed, and fixed in this context means that it's something that is in a medium such that people can come back and see what's going on. Say, for example, a computer file can record a Microsoft Word file, for example, could record somebody's original composition, and in that case, that is fixed. It's recorded in a series of ones and zeros, which can then be later recovered back. Fixed could also mean written in chalk on a sidewalk, or painted on a side of a building. All that matters is it just needs to be in a way that it can be seen and brought back. And then a tangible medium of expression means, again, some along the lines we were talking about fixed, such that it can be seen or perceived, such as the Word file or the painting, things along those lines. The current terms, and notice I say current because the lobbyists are always looking for ways to extend these, but the term is 70 years from the death of the author, and if it's a work made for hire, the term, or other corporate work, the term is 95 years from publication or 120 years from creation, whichever is shorter. So what's not copyrightable? And I always like to, whenever I give this sort of presentation, to try to find a recent case to sort of explain this, but ideas, methods, or systems are the big things that are not copyrightable. Neither are facts. And you also can't register titles, names, short phrases, slogans, or just generally common information. And also public domain works, such as U.S. government works, also are not copyrightable. And it's important to note here that copyright protects the expression and not the ideas themselves. So, like I said, I always try to find a recent case. There's one called Ditocco versus Rick Riordan and Disney and 20th Century Fox, which is just decided on September 20th of this year. It's a case out of the Southern District of New York. And I'm going to post on the website a link to the case. And this is a case involving, well, the defendants are Rick Riordan, who wrote the Percy Jackson and the Olympian series of books. The Lightning Thief, which is the first book, was made into a movie recently. And so the authors of a similar series, the Ditoccos, who had written a book called The Hero Perseus and Atlas's Revenge, had written those, sued, claiming that Riordan's later series were too similar to his copyrighted works. And this one's sort of interesting in the fact that Riordan didn't defend on the basis that he never had access to these particular works. Instead, what he said was that the works were simply not substantially similar enough for there to be an infringement. And in this case, just to briefly explain, both series involved the concept of having a hero. One was named Percy, and the other one is Perseus. They interact with Greek gods, and so you can certainly understand why Ditocco thought that there may be infringement. But in this case, the court looks at it and says, what are the protectable elements here? And here, the idea of having a youth who was involved with the Greek gods, and that just mere idea was not protectable. And there were enough substantial differences between the two. I certainly would recommend reading the case. And like I said, the link to the case will be up on the website shortly. So when does copyright exist? And under current law, copyright exists from the moment of creation. And a lot of people don't really understand that. They think that perhaps copyright is something that they need to register, and that's certainly true, that you get additional benefits, and we'll be talking about those later on. But copyright exists from the moment of creation under current law, and for older works, the answer may be different. Now, the copyright holder under law gets certain rights that they are able to do with their work. The first is the right to reproduce the work. The second is the right to prepare derivative works, and a derivative work is a work that's based on the original. The next is the right to distribute copies. Then there's the right to perform the work publicly, and then the next major one is the right to display the work publicly. There is a sound recording right that's additional to these, which is the right to perform the work publicly by means of a digital audio transmission, but that doesn't apply to most people. So those are essentially the 5 major rights, plus that 6th one, the right to reproduce, derivative works, copies, perform, and display. And this will come up later when we're talking about what's an infringement. So who is the owner? Normally, it's the author of the work that's the owner, unless those rights are assigned to another. Now, the owner of a physical copy does not normally own the copyright to the work itself, and that's an important distinction. You may own a book, but you likely don't own the copyright to that book. You may have the right to keep your copy and to use it, but you don't have the right to take your copy of the book and reproduce it or publicly display it. It's simply not within the bundle of rights that you got when you purchased your book. Now, there's a special situation that often comes up, and that is works made for hire. And this normally comes up in two ways. The first is copyright in works that are prepared by employees now during the scope of their employment. And under the first prong of the work made for hire section, these works are presumptively owned by their employers because these are works that are prepared during their jobs. However, the second is the one that comes up most often, and that is you want to hire somebody who's an independent contractor to create something for you, say perhaps a website or things like that. And in that case, there are certain types of works which can become essentially a work made for hire and therefore owned by the copyright, well, by the person requesting it. But the contract has to specifically stay that, and it has to be a signed written contract. Now, a website is one of those particular examples that may or may not qualify, and actually likely won't. So in that case, what the person would need to do if they really wanted to own the copyright to that particular work is they would need to have an assignment prepared. A lot of people also have works made for hire agreements, which take what we call a belt and suspenders approach, in which they say that this is intended to be a work made for hire, but if it should ever be determined not to be a work made for hire, then this also operates as an assignment. And that's sort of a good practice. Another question that comes up a lot is, do I need to register my copyrights to have protection? And the answer is no, not under current law, but there are certainly advantages to federal registration. And now, under older law, registration was a prerequisite to protection, but under current law, as we said before, copyright exists from the moment of creation. So you have a copyright, but you won't be able to sue in federal court unless you get a registration, and you may or may not be entitled to attorney's fees or statutory damages unless you have a registration. We just covered that. What benefits are there to registration? Registration is necessary before suit can be filed, and then again, that statutory damages and attorney's fees. Now, there are certainly some special circumstances that come up, especially for publishers, and that is a compilation. And that is a work formed by the collection and assembling of pre-existing materials. And in order for a compilation to be protected, that work must be selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. And this is interesting because when you have copyright in a compilation, it's protectable only to the degree of originality that's expressed there. There's an old copyright doctrine called the sweat of the brow, which rewarded people for their efforts in preparing the compilation, and that's no longer enough. There's a great case from back in the day involving a telephone directory called the Feist case. And in that case, what had happened was two telephone companies sued each other because one had simply copied the other's telephone directory, and they tried to claim that they had copyright in the compilation in creating the telephone directory. And in this case, it actually went all the way up to the Supreme Court. What the court said was that the sweat of the brow in creating this telephone directory was not enough. There was no degree of originality in simply putting forth an alphabetical list of names, address, and telephone numbers. Another situation which comes up a lot is called derivative works. And a derivative work is a work which is based upon one or more already existing work. And it's required to transform or change a pre-existing work. And it can be independently copyrightable if it is original work of authorship and if the underlying material was used with permission. And the scope of protection for a derivative work is limited in that it only covers what is added or changed. And only the copyright owner can authorize a derivative work to be made. One thing that where this comes up a lot is a website. People may not realize that copyright will protect the look and feel and the content of their website, but they may not realize that every time they update the website, it's considered a derivative work, and they likely should register each significant change to that derivative work. So how do I register my works? Here's a screenshot of the Copyright Office website, which is very easily found at copyright.gov, G-O-V. And this is fairly straightforward. The Copyright Office has gotten a lot better in providing their materials. They, like the Trademark Office, they've certainly tried to do things online. They've got a great system where you can search prior registrations and documents relating to it, such as assignments. They've got an online system where you can register your work, and that works fairly well. Certainly not as smoothly as the way the Trademark Office systems work, but they're certainly better than not. And we'll talk about this a little bit in terms of fees, but certainly the Copyright Office wants to encourage you to use their online system, so it's currently cheaper to file online than it is on paper, but if you still want to file on paper, you certainly can at a higher fee. Now, we talked about this briefly, about the Copyright Office website. In addition to what I talked about prior to that, I wanted to let people know that they have a great section of circulars, which can be found. I'm currently pointing the mouse over here to the circulars and brochures section, and from that section of the website, what you can able to do is get information on particular topics of interest. So if you have a real question about what it takes to record an assignment, you can look at that there. If you have questions about what it takes to record a particular kind of work, likely they have a circular or a brochure explaining that particular issue. As we said before, it's currently cheaper to file online. It's currently $35 to use the online system. If you need to use the paper forms, currently they cost $65. And I've got the link there for the full list of fees. Now, we're going to switch now to the next major topic, which is the area of copyright infringement. So if anybody has any questions of what we've gone over already, now would be a good time. Otherwise, we'll just go ahead and launch into copyright infringement. Now, as we said before, there are certain rights that come with having a copyright. And what, as we may recall, is such as the right to perform the work publicly, the right to have copies made, the right to prepare derivative works, etc. And in order for a work to be an infringement, what's required is an action by someone who's not the owner that usurps or interferes with one or more of those exclusive rights. So in order to be an infringement, you have to be able to point to a specific right that's granted under the Copyright Act that has been usurped or interfered with. Now, if you're able to prove infringement, you're able to get certain things such as injunctive relief. You can get a court to rule that whatever you want, like the publication, has to stop. You can have infringing works impounded or destroyed. You can get compensation, in the terms of damages and profits from the infringer. And in certain circumstances, you can get costs and attorney's fees if you have a registration that qualifies for that. You usually have to have a registration in place before the infringement occurs or within 3 months of publication for that to happen. And another option, if you don't, because to be perfectly honest, a lot of copyrighted work, it's really difficult to prove, actual damages and profits. So the law is designed to punish infringers by setting up a regime called statutory damages. And these range, the normal are between $750 and the low end of $30,000. And the actual amount is determined by the trier of fact, which could be a judge, but it's more likely often a jury. And in cases of willful infringement, where you can prove that the infringement was done willfully, those damages can be increased up to $150,000 per act of infringement. There's another doctrine of innocent infringement, where you truly didn't realize that what you're doing was an infringement, and the judge agrees, or the trier of fact agrees that it was an innocent infringement. That can lower the statutory damages down to $200 per act. Now, there are certainly defenses to infringement claims, and we're going to go through some of them here. I've got a full list of them here. It's important to note that innocent infringement is not a defense. Just because you didn't mean to doesn't mean that you're off the hook. It just reduces the amount of damages. But the important ones we're going to talk about here are fair use and parody. Fair use is a doctrine which comes up a lot, and it's certainly one that is very often misunderstood. And what a lot of people don't realize is that there is a four-factor test that courts look at to determine whether or not something is a fair use. But before that, what they really don't realize is that it's a defense to infringement. And so if you make the claim, well, I thought it was a fair use, and the judge or the trier of fact disagrees, you're still going to be liable for that infringement. So what they look at is first is the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and then the effect of the use on the market for the copyrighted work. And the purpose and character of the use is often looked at, is this a commercial use that's the infringement? Is this going to affect the market for the copyrighted work? What is the nature of it? Is it and then importantly is the amount and substantiality of the portion used. There's a great case involving the publication of Gerald Ford's biography, in which it was deemed to be copyright infringement for a reviewer to quote from it's essentially the key portion of the Gerald Ford biography, in which he's talking about the pardoning of President Nixon. And in that case, the amount and the substantiality of the portion used was deemed to be significant enough that it had a significant effect on the market for the work, and was deemed to be an infringement. Now, it's important to try to avoid copyright claims when you're using content, especially things you might find out on the internet. One thing that comes up a lot is people want to use images for presentations or so forth, and they see it and they think it's out on the internet and it's something that they can just take, and that's simply not true. At least not for the great majority of things that are out there. It's important to try to track down who the owner is, and you can use the copyright database to try to look up things if it's a registered work, or usually there's enough information or metadata about what it is that you're trying to copy that you can try to figure out who to request permission from. But it's also important to note that not all works require permission. So for example, there is a doctrine called the Creative Commons license, which is I certainly something that I would recommend people check out. It's more information is at creativecommons.org. And a lot of the works that I publish on the web are done on a Creative Commons license, in which I allow the people to share things that I put out on the internet, and with certain restrictions, such as they have to attribute them back to me, and they're not allowed to make substantive changes to what I put out, but they are available and ready for use. And there's more information there. We will be doing a webinar on copyright and Creative Commons as one of our upcoming webinars. Now is a good time again to switch topics here. Slightly, we're still talking about infringements, but we want to talk about certain ways of handling online infringements. And the biggest is a way to handle things is under what's called the Digital Millennium Copyright Act, which is now codified as part of the regular copyright law. But people still talk about the DMCA and its provisions as if it was something separate, but truly it is part of the Copyright Act. So we're going to cover briefly what is it, what's a notice, and what are the steps involved to getting things removed, and what things that you should do if you don't like the results. The Digital Millennium Copyright Act is Section 512 of the Copyright Act, and it essentially provides that an online service provider, such as a website host or other content provider, has a safe harbor from liability for the hosting of infringing content if it complies with takedown notices that are sent from owners. And an important step in this process is the OSP is required to designate an agent for service of these notices. A lot of people think that they can, just because they're a service provider, they can take advantage of the DMCA, and that's simply not true. They need to designate an agent in the Copyright Office. There's a procedure and a cost for doing so. And to qualify for the safe harbor, the service provider must not have actual knowledge of the infringement, must not receive direct financial benefit, and must act quickly to remove the infringement once there is notice. The steps here are given for the format for a DMCA notice. You're required to have a signature, or physical or electronic. You identify the work, identify where it is, and contact information. And then you have to make a statement that the complaining party has a good faith belief that the use is not authorized by the owner, and that that notice is accurate. So provided that you provide a proper notice, the notice is given, the service provider is then required to take the material down and then notify the user who uploaded the material. If taken down wrongly, that user can provide a counter notice. It's similar to a regular notice, plus a statement that they will consent to jurisdiction in federal court. And then, if they do provide the counter notice and the complainer doesn't actually file suit to prevent the information from going back up, the material should be put back up by the online service provider. Now, why should someone submit a counter notice? The most common reason is fair use or commentary. Perhaps the notifier is not the owner or agent for the infringing work, because only the copyright owner or their agent can complain, or misidentification of the infringing work. There was a dispute in the last set of presidential elections where the content for the I believe it was the McCain campaign were being taken down under DMCA takedown notices, and simply they were complaining that the timeline, with the 10 to 14 days before the material could be put back up, because their stuff was being falsely accused, was not timely enough for them, and essentially they were told tough. It's this is what the statute provides, and applies to everybody, including presidential campaigns. So that's a good brief overview, and it's certainly something what I'd call basics. I could go on for hours talking about copyright. It's certainly as I've said before, it's a topic that's near and dear to my heart, and it's something that I truly enjoy helping people with. If there's any questions, now would be a good time. Well, I don't see anything currently showing up, so hopefully it means I've been relatively thorough. What I'd suggest is people check out, as I've said before, our blog at blog.davismcgrath.com/webinars, in which we'll be posting the recording for today's session. And we will. I'll also be posting a link to the Ditocco case that I talked about, and also be posting up copies of my slides. So I certainly want to thank everybody for attending. And again, our next seminar, webinar will be coming up on November 2nd on the topic of common trademark application problems. So thank you again for attending.